Welcome to the Taxpayer Podcast, a podcast production by the Taxpayer. For more informative discussion on tax law, please visit our website to learn more about the Taxpayer Journal.
Peter, nice to see you again.
Hi, Trevor. You too.
Sands of time are slipping through our fingers as the end of December approaches. But here we are.
Geez.
And I think our topic today is to look at applications to the High Court versus appeals to the tax court.
Exactly.
I don't know if you want to kick off, or shall I?
I'll kick off because I actually had two cases dealing with this topic this year.
Okay.
And I'm sad to say that lost both of them. So, but just to kind of discuss those two briefly and just what happened there. So they were both administrative reviews in terms of the Promotion of Administrative Justice Act, the PUJ Act. And there, as we all know, the Commissioner's decision to levy a tax assessment is administrative action in terms of PUJ. And then in terms of PUJ, you need to first exhaust your internal remedies in terms of Section 7, which means continue in the tax court unless exceptional circumstances exist. And there's no definition of exceptional circumstances in PUJ. And then separately, and we'll chat about this, Trevor, the Section 105 of the Tax Administration Act says that unless a court otherwise directs, a taxpayer must continue in the tax court. So if there's a high court approach in terms of a review, it needs to decide if there are appropriate circumstances for going to the high court as opposed to remaining in the tax court. But the recent case law, including my two cases, seem to interpret appropriate circumstances as having an equivalence with exceptional circumstances. And I think that was because Section 105, when it was first introduced in 2012, seemed to give an election to a taxpayer whether to go high court or whether to go tax court. And then in 2015, it was amended to include these words: you need to stay in the tax court unless a high court otherwise directs.
Yeah.
So the recent case law, including the two I was involved in, seemed to imply that unless a high court or court otherwise directs means there must be exceptional circumstances. So it seems however you bring your review, whether it's under PUJ or principle of legality, you end up having to show exceptional circumstances before you can have your matter heard by the High Court. And I think that has become a real obstacle to moving across from the tax court into the High Court.
If I can just interject there and say,
please.
That's one of the things that really disappoints me about our profession, because it's judges who have said that when the High Court otherwise directs, there must be exceptional circumstances. The Section 105 does not use that terminology, and they
doesn't use that terminology.
In my opinion, have very badly let the side down.
Yeah,
they've shown themselves to be what I once heard Sydney Kentridge QCSC once say, become administrative minded. Sorry, executive.
Yeah. And I think there's an argument for that, because the words "unless a court otherwise directs" does not talk about exceptional circumstances. I like the word appropriate circumstances, because you must show that there's a reason for it. The court must have a reason for directing that you go to the High Court and not in the tax court.
Yeah.
But how did that suddenly get elevated to exceptional circumstances? And then, of course, what are exceptional circumstances? It's not defined in PUJ. And in one of the cases I was involved in, the Erasmus case, they were held by Judge Sher to be circumstances which are out of the ordinary, unusual, uncommon, or different. I don't know if that's helpful, Trevor.
I don't think it is at all. And that is lifted, if I remember correctly, from a shipping case where Judge Thring gave the judgment. So it bears no relation to tax whatsoever. And Judge Sher, it's just a little bit strange for me to call him judge, because we actually shared chambers at one stage. And we did privilege together. Mark shared. But Judge Sher, he almost said that they should be the same. That why must you have two tests? They should both have the exceptionality test. Where does that come from? I don't know. It comes from being executive minded.
And if we just go back to, because we chatted about the Absa case in the High Court, and I think we both liked that judgment of Sutherland. It just kind of was clear and it made sense.
Yeah.
And he used that lovely line that I use all the time, that if you approach the High Court, it avoids a long and protracted slog through the tax court. And it's now been held that is not an exceptional circumstance. I don't think, Sutherland referred to exceptional circumstances, but it's now been held that long and protracted slog through the tax court is not exceptional circumstances. But timing-wise, Trevor, I mean, it can take you, as you know, years to get to the tax court, and it can take you a very short time to get to the High Court and to have your review heard by a single judge. So, I mean, there is a long and protracted slog.
Yes, and I think Judge Sutherland in the Absa case in Pretoria, he said, well, the tax court is the default method. So anything else is exceptional. So I think he did use the word exceptional, but not in the sense in which it's now being used. That something very exceptional, or I mean, he put it very nicely, I thought, and I'd stand by this being correct. Let me just find it here. He said the quality of exceptionality need not be exotic or rare or bizarre. Rather, it needs simply be properly construed circumstances which sensibly justify an alternate route. Now, that's a fair way of putting it.
That's a lovely way of putting it.
Yeah, circumstances that fairly justify an alternative route.
And the other point is that the more recent judgments have held that an error of law in itself is not enough to constitute exceptional circumstances. And I think I partly buy that, except it's not a dispute of law that when you approach the High Court, it's where there's an error of law. Yes. And if there's a patent error of law, like if SARS have just got something wrong, they've just issued an assessment, the assessment is clearly wrong on the law.
Yeah.
Why is that not an exceptional circumstance? And I find that in both of the cases that we ran, we weren't heard on the merits. So the court only heard us on the jurisdictional points. And I think the merits are really important, because that's when you come into this error of law and you're able to show potentially that an error of law is so egregious, so obvious, so patent, that a High Court judge should be able to sit there and say, you know what, this is just wrong. It's just incorrect. So I think you get different errors of law, and some probably don't justify deviating from the default path to the tax court, but I think some do. And I think the court needs to hear what those questions of law are. And as I say, to me, there's a difference between a dispute of law, obviously, the disputes of law, that's why you go to court, and an error of law. And I think that distinction has sometimes also been blurred in the more recent judgments.
Yeah. My impression, and I say this with respect, of the judgment of Judge Scher in the Erasmus case, was that it made me think of the judgment of Lewis J.A. in the NWK case, who was in my class at university. So maybe I'm relating to people that I know. But I think she was trying to write a landmark judgment, and she got it horribly wrong. And I think the same is true of the Erasmus case, with the greatest of respect. And Dennis Davis has written an article in the Taxpayer which supports these judgments, but even he suggests that Scher J might have gone a bit too far in the Erasmus case.
And when you just look at the way that you can bring something on review, I mentioned that both of our cases were under PADJA, so administrative review, but you can also have a review under the principle of legality. And the legality review is a review where the decision maker acted outside of their powers, so they acted ultra vires. Yeah. And there you challenge the conduct of the official on the basis that it constitutes the exercise of a public power. So you don't have to go through PADJA and face this internal remedy issue. If you go principle of legality, you don't have the Pudger issue, so then you straight into Section 105. And if Section 105 is not interpreted as requiring exceptional circumstances, then you can go to a high court without having to show those exceptional circumstances that nobody seems to understand what they are. So, but just interesting, there are a couple of different ways of taking something on review, although Pudger is sort of the more normal one, I suppose, because it generally is an administrative action.
Yeah.
And taking of an assessment or making of an assessment by the commissioner is an administrative action. So that's sort of your typical review.
Yeah. So I suppose that, apart from debating all of this sort of academically and not so much and practically as well, but the takeaway for taxpayers is you've got to think very carefully before you decide to go to the High Court. But to my mind, there's a constitutional issue involved as well, and I have had on very good authority, namely people who are actually involved, that the forged packaging case and the wrapper case and manganese, Kalahari manganese, that case, those three are going to the Constitutional Court in a single hearing. So the last word has not been spoken. Or to put it more colloquially, the fat lady hasn't spoken.
That's exactly right, Trevor. I think it's exactly right. That I think it's those three cases are going to the Constitutional Court, and I think that is great, and it's important. If we get some final law on this. Just talking about forged packaging, because I think that was Judge Binns Ward. Now I can say Advocate Binns Ward because when I was doing articles, he was an advocate, although he is a bit older and more senior than me. But I think that was held by him in the Cape. And that case held that there wasn't just a question of law, there were also questions of fact. And that, obviously, if there are questions of fact, then you have to go to the tax court because that's where all the facts are unpacked and you can lead evidence and you can cross-examine them, etc. But he also made the point that even if it was just a question of law, nothing stopped the taxpayer from requesting the tax court to hear and decide that point separately from the other issues if it would be dispositive of the matter. And I think that there is something in that because you can separate out issues in front of the tax court. So you can go to the tax court and say, please, would you hear us on this point? I think there is an error of law. I think it's dispositive of the matter. And so you sort of stay in the tax court channel, but
yes,
you go on a single issue.
It's all very easy, and I'll call him Ashley, for Judge Binns Ward to say that, I think he went so far as to say he can't see a court saying no. Well, I certainly can. A judge might turn around and say it's not convenient to do it that way. We'll do it all together. And to me, that's the heart of this constitutional dispute. The Constitution guarantees the right to fair and just administrative action. I'm just not making up the words, but I'm not using the exact words. And that means that you can have decisions set aside purely for procedural irregularities and without having to deal with the merits. But when you go to the tax court, you've got to, but SARS files a Rule 31 statement, the taxpayer files a Rule 32 statement. Those are your formal pleadings. You've got to deal with the merits in that. And then the merits start influencing the procedural side of stuff. Whereas all other citizens can go to the High Court and challenge something because it hasn't been procedurally dealt with correctly and have it set aside without the merits being involved. But if you go to the tax court, you've got to plead the merits, and it's just and that makes taxpayers second-class citizens as far as their administrative rights are concerned. And to me, that's the constitutional issue, and that's where the judges have let us down badly.
Often, Trevor, you talk about the Metcash case as well, because that's where this all started. I think that was sort of because that went on to the constitutional. The Metcash case, the pay now, argue later, that assessment way back in 2000, where the Constitutional Court was asked to talk about or rule on the validity of the pay now, argue later concept in the light of VAT. And it said it was settled law that the High Court had jurisdiction to hear and determine tax cases. So that for me was kind of the first case, landmark case, that sort of said you can approach the High Court in relation to tax matters. In your words, you're not a second-class citizen just because you are a taxpayer and you have to go through the tax court. And I think that's, I remember you talking about that case. Of course, it was before Section 105 because the TAA only came in 2012, and this was 2000. But we've already said Section 105 itself doesn't say there need to be exceptional circumstances. So Metcash, to me, we've got a constitutional court judgment on this principle.
Yeah, and what I've considered to be a ray of hope is the recent judgment handed down in the Supreme Court of Appeal on the 8th of November, and it's Leuven Metals Pty Limited versus SARS. And there's a dissenting judgment that he concurred in the conclusion, but there's a dissenting judgment of Molamela P, president of the court, and he makes some excellent points, because in reading through these other cases, I kept saying to myself, what about the Langholm Farms case and the earlier Kalahari manganese case, where the court did entertain these applications, and he has raised that in his dissenting point, because the majority where Ponnen gave the judgment said that the High Court had not even considered whether it should be entertaining this thing at all, and in fact held that they shouldn't have been. And it's very disappointing that three other judges concurred with that. But the president of the High Court, of the Supreme Court of Appeal, dissented on that point. And he pointed out that the Langham Farms case and the United Manganese of Kalahari case both did entertain these applications. And they were both heard after the 2015 amendment to the Tax Administration Act, which speaks volumes. So and they relied on Metcash. So and he says here in his judgment that said these courts had not considered the dictum in Metcash to have been impacted by the 2015 amendment. You've got the president of the Supreme Court of Appeal talking sense. So good for him.
And in the Erasmus case, Judge Sher held that Section 105 has now considerably restricted taxpayers' ability to approach the High Court for relief. Yeah. So there you go.
Metcash is ancient history. It's irrelevant. This is the answer to it.
It's exactly the answer to it.
Yeah.
And just on the other cases you mentioned there, Trevor, so Rupper Resources and United Manganese Kalahari, both going to the Constitutional Court, as I understand, and Rupper Resources also concerned the levying of VAT assessments, and the UMK concerned adjustments to taxable income. And the SCA in those cases hold that Section 105 is there to ensure that you stay your course, that in the ordinary course, tax disputes are taken to the tax court, and the High Court only has jurisdiction when the circumstances justify it. And again, Ponnen held that the applicant needs to show, Judge Ponnen, that exceptional circumstances were present. So we need the Constitutional Court to rule on this point regarding exceptional circumstances in the context of Section 105. And also what exceptional circumstances are, because, in the Absa case, Sutherland and the High Court talked about the long and protracted slog to the tax court, through the tax court, and also whether a question of law is an exceptional circumstance or not. And I think the whole concept of bringing in exceptional circumstances raises these complicated issues about what is an exceptional circumstance and what isn't. And you can't make a blanket rule. And I think that's the problem with elevating this issue to the concept of exceptional circumstances. It's you then need to decide what that is, and that's not easy to do.
Yeah, and in this Leuven case, the majority judgment was written by Judge Ponnen, who I think is close to retirement now, and a few other things I could say but won't. But he seems to have his nose somewhat out of joint, let's just say that. But what he does is he takes what was said in the Metcash case, which referred to the Friedman case and various other cases, saying that if it's purely a legal point, the High Court has jurisdiction to hear it. And he goes back to those judgments and traces through them and say they all go back to an earlier judgment which uncritically accepted what would held in, I think, a Natal case, thereby impliedly suggesting that none of this is good judicial precedent. Now, to me, that's just wrong. You know, if the Supreme Court of Appeal previously or the Constitutional Court now just accepts something as being the law, even if it's just based on uncritical acceptance of what had been held before, that is binding on us. And so what was held in Metcash, being the Constitutional Court, is binding on Ponnen, and you can't just unpick it by going back. I mean, it's binding on me and it's binding on you. It's binding on all taxpayers. Why shouldn't it be binding on Ponnen J as well? You know, the Supreme Court of Appeal can depart from one of its own decisions if it's satisfied that it was clearly wrong. But Metcash is Constitutional Court, so you can't just treat it like that. And I remember Owen Rogers saying to me, Justice Rogers saying to me, and he's just written an article I only saw today in the Advocate magazine. We've got quite an exotic title, so it'll no doubt make interesting reading. But Owen jokingly said to me, if there's one thing he dislikes more than taxpayers, it is judges who don't follow judicial precedent.
I can see how that would offend
that he wrote where he found that to be the case.
Of course, he's in the Constitutional Court where he absolutely belongs. So it'll be very interesting when he gets hold of these matters. And I think that, Trevor, there is a human element when it comes to judges in the High Court deciding these sorts of matters, because I think the instinct is, you know, this came from the tax court. That's sort of a specialized court of revision, even though a High Court judge sits in the tax court. And if I decide this matter, it's going to be dispositive of it. I don't have witnesses, etc. And it's very easy to say, go back to the tax court. And the High Court judges often don't have tax experience as well. And in a tax court, the judge or the president of the tax court sits with assessors.
Oh.
So I think it's quite easy for a High Court judge to default to sending it back to the tax court. And I think that probably particularly in respect of anti-tax cases, where you kind of think, well, there should be some issue of fact involved, even if in fact there isn't. And I think that segues into the Emslie case, because the Emslie case was a GAR case, an anti-tax avoidance case. And Emslie's position was very simple. It just says there needs to be an arrangement, and an arrangement means I need to have acted in concert with the other party. And all Emslie did was subscribe for preference shares in various Macquarie entities. Macquarie did a whole lot of transactions that SARS didn't seem to like, but Emslie didn't do this by arrangement with Macquarie. I just invested in preference shares. And there the SCA said, well, there are questions of fact here. And I think that's a very easy sort of way to get out of jail, if you like, if you don't want to hear a matter and you want to send it back to the tax court. You just say the issues of fact involved, especially in GAR-related matters, I think.
Yeah, and if I may mention, the now retired Judge Davis, who's our fellow editor of the Taxpayer, Dennis Davis, he suggests in an article which is in the November-December issue, which, by the way, will be distributed tomorrow, he suggests that there's something about a GAR assessment where there will always be a dispute of fact. To me, you can't say that. The facts might be absolutely common cause, but SARS has made one error of law, and that error of law will make all the difference. And an example is the purpose test subjective or objective?
Mm.
That could
That's
be
a great example.
Yeah.
That's a great example, Trevor. I hadn't thought of that. Because we know that SARS has been arguing for many years that the purpose test is objective in the context of GAR, Section 80, capital A. And as far as I know, the vast majority of tax advisors have said, no, it's a subjective question of fact of the particular taxpayers. And there's been no GAR law, case law. And I think partly because this has now become a really important sort of binary point for SARS and for taxpayers. And I think we really need law on that. And that's a perfect question of law. And it's a GAR point. So that could easily be something where you could say, hang on, SARS, you've said this is an objective test. Clearly it isn't. Purpose must always be subjective. Let's ask the tax court to decide so we don't spend 3 years wading through discovery, etc., to try and get to the tax court on this aspect.
Yeah. I think you said the tax court, you meant the High Court. Let the High Court decide.
Yeah, but you don't want to spend 3 years only to end up in the tax court. You want to go to the High Court and they can decide quickly. Mm-hmm.
Exactly, yeah. Can I just mention, Dennis Davis wrote an article in the latest Taxpayer dealing with all of these cases. And in his final paragraph, he says the following, and I've got it in front of me, so I'm quoting it now. He says here, there is a further point. Many of these cases appear to have embraced a, quote, Stalingrad approach, unquote, to tax litigation, rather than having the matter properly aired before the statutorily designated body, being the tax court, in which a comprehensive expert evaluation of viva voce evidence can be undertaken. The subversion of the statutory mechanism by well-heeled taxpayers to circumscribe the purport of Section 105 of the TAA is clearly an important inarticulate premise in these judgments. Now that's written by a newly retired judge. If that is so, I think it's an absolute bloody disgrace. You treat all taxpayers equally, whether somebody is well-heeled or not is entirely irrelevant. And I don't think, if any taxpayer can go the short route rather than the long route to solve a legal issue, it's got nothing to do with how, it's not something that only wealthy people can afford.
It came up in both of my matters, Trevor, exactly that point. The SARS counsel said the reason we're here is because there's a Stalingrad type approach and the taxpayer is trying to drag this out and they're trying to drag their heels. And I was genuinely surprised because, in fact, it was exactly the opposite. The taxpayer was frustrated with the long process of getting to the tax court and wanted to circumvent that and say, let's go to the High Court and have this matter disposed of immediately.
Yeah.
And it's not to take longer, it's to take shorter. And that's, as you say, it's got nothing to do with money. In fact, if money was an issue, again, it would be more of a drive to go to the High Court and avoid the tax court so you don't have to go through discovery and pay lawyers a lot of money to kind of, to run a matter for 3 years. So I was really surprised at that sort of angle. I see it exactly the opposite. And when we advise our clients to go to the High Court, that's the basis. We say, guys, we're acting against our interest. We get paid by the hour. I'd love to run the matter for 3-4 years, but in your interest, acting in your interest, it's better to go to the High Court and have the matter disposed of immediately. So that approach I don't get.
Yeah. And one picks up from Judge Scher's judgment in the Erasmus case that he got a bit irritated with counsel for the taxpayer for pouring a bit of scorn over the tax court. I can fully understand why one would be tempted to do that, having appeared in it for more than 30 years. It's the same judges who sit in the High Court who also sit in the tax court. And yes, in theory, it's a specialist court, and you've got an accountant member and a commercial member. And yes, sometimes they are useful, but many times they sit there and don't say a word. And you don't necessarily have to say a lot of words, but only the judge can decide legal issues. They are confined to issues of fact, and quite often the facts are common cause, so they have very little role to play. So one mustn't elevate the tax court to the status of a court that can arrive at the truth in some magical way that a high court can't. The real difference is the one is done on the papers and the other one is done with evidence.
And interestingly, in that case, and it's nice that I can comment on this because I've listened to the argument, and our counsel didn't disparage the tax court at all. Just made the point that it's sort of a court of revision, and it's the same judge who will hear a matter in the High Court will be appointed to the tax court, albeit in a different capacity. And Trevor, your point that there are two assistants, but that doesn't elevate it to a different status. And I thought it was a very unfair comment on the record to say that there were disparaging comments made about the tax court, when in fact that just wasn't correct. So,
I wasn't privy to it at all, but I just read it in the judgment and it looked out of place to me to say that.
Just interestingly, because the tax court has been described as a court of revision, because the court revises or adheres assessments and it can set them aside and it cannot set them aside. So it's not really a court of appeal, it's a court of revision. But
it substitute its own decision for that of SARS.
The commissioner. Exactly. And of course, the big point for me is obviously that you have evidence led and you have witnesses led and you can cross-examine, etc. So, but that's very simple. If there's a question of fact, you can't go to the High Court, then you must stay in the tax court. We all accept that. That's not a problem. But where it's a question of law, you should be able to go to the High Court. And as I say, they're different, especially if it's an error of law and it's a patent error of law. I don't think that you should say that cannot be an exceptional circumstance. And as I say, often you don't get to that because you don't argue the merits, you just argue jurisdiction. So you kind of, and it's just astonishing how there's been this wave of judgments, or sort of the High Court sending all these matters back to the tax court. And I think many of them unnecessarily. And so it'll be very interesting to hear what the Constitutional Court says about these points. I can't recall any other situation which there've been like six judgments, all involving the same issue, Section 105, just all. And some of them not even reported. I heard about one of them from a colleague at the bar, and just one other aspect, we may have said this before, but the forged packaging case, that was Binns Ward sitting in the High Court. But it started in the tax court, and Judge Clutie in the tax court said, no, the tax court doesn't have jurisdiction. You must go to the High Court. And she delayed things so that they could bring the application in the High Court. Go to the High Court. Now, I would have thought that in itself constitutes exceptional circumstances. And then the High Court says, no, should have been heard in the tax court. I don't know. I didn't realize that's very interesting.
That's exactly what happened. And so they appealed.
That's in the middle.
And I mean, talk about the law being an ass, And then they appealed. And I'm not involved in it at all. Then they appealed Binns Ward's decision to the SCA, which refused leave to appeal. And then they appealed applied for leave to appeal to the Constitutional Court, and now they're going.
And I'd love to know, we'll find out when that date is, and then we have a podcast as soon as that judgment comes out, Trevor, because I think that's going to be super interesting.
The one thing that worries me, and this is no disrespect to the other members of the Constitutional Court, but Judge Rogers, we know he did a lot of tax work when he was at the bar, and he's interested in it, and he's super competent in everything. But I believe he's taking a year's sabbatical next year, so he might not be part of the bench that hears those matters. I hope I'm wrong about that.
I also hope you're wrong, because as you say, he's an absolute legal giant and he has a huge amount of tax knowledge as well. So I think the court would be the poorer in respect of tax matters if he's not there. But we should find out about that. Trevor, has always been super interesting. In fact, particularly interesting today. So enjoyed our chat, and good one to end the year off on.
So I suppose the takeaway for viewers and listeners and taxpayers is just think twice before deciding which avenue to follow. Because you never
So
know
to
what lies around the corner.
to be very careful about going off to the High Court now, because you do have this whole raft of judgments going against taxpayers approaching the High Court. So I think that's really tricky. And then wait and see in terms of the Constitutional Court and what comes out there.
Yeah. Okay, well, that's a. We look, if I can put it crudely, we look forward to the fat lady singing in the new year.
Absolutely. Thanks, Trevor. And happy Christmas and New Year and all the rest to all of our viewers and listeners, and to you as well, and to the Taxpayer team.
Yeah, and likewise. Yeah.
Mm-hmm.
Have a good break and we'll get back into it. The thing about that I enjoy chatting to you, enjoy this equally. So it's hard work, but we enjoy it.
Yeah, for sure.
That's the thing about it.
Thanks,
Okay,
Trevor. Thanks a lot.
Thanks very much.
Cheers. Bye.
The Taxpayer is hosted by the editors of the Taxpayer Journal, Trevor, Emslie, and Peter Dachs. For more information on our journal and other products, please visit our website at taxpayer.co.za. Each of our episodes is CPD certified. To claim your CPD points, please visit our website. Thank you for listening to the Taxpayer Podcast. You can find more episodes on your favorite podcast platform or on our website at taxpayer.co.za. Please like and subscribe on YouTube and rate our podcast on your podcast platform of choice.